Welcome everyone. Super excited to host this webinar with Deborah. And today, as the topic suggests, we'll discuss about the FTC crackdown on data flows. And it'll be like full power packed with a lot of guidance in terms of what the guidance means. And what we would love to do at the end of the webinar is have some level of guidance to you as well in terms of what you can go back and implement in your company and make sure your apps are more compliant to the guidance and overall different laws. So with that, I think super excited to start the webinar and kickstart it. I think we can start with the quick round of introduction. So I'll go first. Hi everyone, I'm Vaibhav. I'm founder and CEO at Privado. Prior to starting Privado, I was working in product management. So literally building products, working with engineers, building mobile apps and applications and products and backend systems. Today, what I do is I mostly work with privacy and security teams, helping them make their apps and products compliant with laws like GDPR, FTC guidance, and ultimately help them win customer trust. And Deborah is our privacy advisor, so it's been super exciting to work with her on the product and get her guidance. So over to you, Deborah, for your introduction as well.
Sure. Thank you for having me. I'm Deborah Farber, and I am like Vaibhav said, a privacy tech advisor for Privado. I have been for the last year. In fact, we were matched as part of our working together at the Rise of Privacy Tech, where I'm also an advisor. And I encourage you, if you're in privacy tech and want to get it, really plug into what is going on in the space and how it's growing up and getting defined, reach out to the Rise of Privacy Tech or reach out to me and I'll give you more info. I've been in privacy for over 16 years, operationalizing it into the business. But in recent years, and I'd say the last year and a half, I've kind of done a real pivot into helping, instead of helping with governance, risk, compliance, or being relegated to only those areas, I shifted over to really kind of helping the privacy tech arena flourish and bringing innovation to market. And so part of my excitement in working with Privado is that we are working together to shift left, so to speak, and really bring privacy engineering tool sets and capabilities to software developers. So, the DevOps folks. So far it's been really fun. So I could talk on and on about privacy and myself, and I don't want to do that. So let's move on to the next.
Awesome. So thanks for the introduction, Deborah. And what I thought, kicking off the webinar, of course, there's a lot to unpack in terms of what the FTC guidance is all about. I thought it would be really fun if we can sort of talk about the context and the background of that as well. So over to you for that.
Sure. Yeah. So what's going to happen now is I'm going to tell you, I'm going to really kind of set the scene and give a little bit about what the FTC and HHS has been doing and the guidance that they've been giving out post since the Dobbs case has overturned Roe v. Wade, and what are the implications and why is the federal government acting? And then I'm going to turn it over to Vaibhav to talk about what does that practically mean from more of a technology requirements, workflow perspective. So first up, the Roe v. Wade judgment really has created a bunch of privacy risks in that it's a game changer for where we are today in how decisional, how we make decisions, in how Roe v. Wade is really what the case the holding for Roe v. Wade was pretty much recognized an implicit right of privacy called a penumbra of rights in the U.S. Constitution. And so, then there were some follow-on cases in other areas of privacy as well, where it's not just right to abortion, but right to contraception, right to, gay marriage, right to, have the government not intrude on some of your decision-making, right? And so with Roe being overturned, it's, there's this fear, and a valid fear, that there might be more risk to individuals in the states where, someone is seeking an abortion and it's illegal. because any of that data about them could now, if it's shared with even just a third party advertiser, or with like it's not the government, right? You're just sharing it, maybe with a data aggregator gets this data and then sells it to they sell it as quote unquote anonymous, and they'll sell it to the third parties. They might even sell it to the government, like a company like SafeGraph, for instance, has been recently chastised for making claims that they have anonymized data sets and then selling them to the government, where it was precise location data that the government very well could re-identify. So is it really anonymized if you're able to re-identify? So because of those fears and the fact that we have such a data collection, data heavy, society over the last 15 years or so, it's been this big data world. Let's collect whatever we can. There's now this renewed fear that, through subpoenas, or even just purchasing data on the open market, that governments can now be able to track and find out who might have helped get an abortion, for instance, and then there's a lot of risk to those individuals, right? So. Sharing health data, for instance, right? Pregnancy and abortion data is really, really sensitive, right? As one might think. Oh, sorry, I wasn't ready for the next slide there yet. So the first thing is that, what are the risks? The risks to the individual who's either seeking an abortion or helping, or helping someone else to get an abortion. The risk is that they could be criminally prosecuted for murder, or assisted murder, or there's a whole bunch of really let's just say crimes, in addition to civil lawsuits. So and those civil lawsuits could also be had by the company who who gave up that data and shared it without consent to third parties. So Biden's White House came out with a directive to the FTC, who has the authority. The FTC already has the rulemaking authority to be able to prosecute for unfair trade practices or for deceptive trade practices. And they have, as a result, been helpful for privacy for many years, as they are one of the main privacy enforcers. And they have broad discretion. And so we could talk about that in a little bit, but we'll talk about Biden's directive. We'll also talk about the Health and Human Services clarifications around HIPAA and education around when that applies over, state laws, and to, remind people. And then Elizabeth Warren also came out with a proposed bill called the Health and Location Protection Act to also shore up this risk and, try to, prevent the risks and prevent harm. So next slide, please. Yes. Thank you. So first, we'll talk about when organizations are sharing health data, in that they can expose individuals to criminal prosecution and lawsuits. So current practice of collecting and retaining extensive records of cell phone location data will allow it to become a tool for extremists looking to crack down on people seeking reproductive health care. The senator, that quote was from representatives in Congress. And then Dana Sussman from the National Advocates for Pregnant Women, she said, "We've already seen, but we anticipate that tech companies will be issued subpoenas for people's search histories and search information. And under our current laws, and this is totally legal to do. So how do we prevent that? How do we prevent people from feeling mistrust towards organizations that they are sharing their data with? Great questions. We're going to get to that when Vaibhav gets to his piece. But the next slide, please. All right. So as a result, here we've got issues of, those who in the states where abortion laws or anti-abortion laws have gone into place, you now have this states versus the federal government's desire to, legislate or, to protect what they believe is worth protecting. So at this point, you've got the Biden administration. They wanted to really do whatever, flex the power of the federal government where they can to protect individuals here. And so he issued a directive to protect the protect the health and location data of users, or I should say individuals. I actually want to, we should look at users as humans, not as users. So I'm trying to get rid of the word users from my vocabulary. But to address the potential threat to patient privacy caused by this transfer and sale of sensitive health and health data, and to protect people seeking reproductive health services from fraudulent schemes or deceptive practices, the chair of the FTC is encouraged to consider actions to protect consumers' privacy when seeking information about and provision of reproductive healthcare services. So really wants to, Biden really views abortion as healthcare. And so therefore is leaning into HIPAA, leaning into wanting to protect the provision of that reproductive health care. So I just think it's important to kind of give some context around that. Okay, next slide. Now, so Elizabeth Warren, also being a member of Congress and not the executive branch, right, has more influence to be able to create some, not that she doesn't have the rulemaking authority, but she's got the ability to introduce bills, and has proposed a bill for the Health and Location Protection Act. And this would prohibit the sale or transfer of information about location and health data. And it would then, it would explicitly task the FTC with developing rules to implement this ban. And there are some levers that the FTC can then use, which we'll talk about in the next slide, that can really explain more about how they could go about doing that. But for now, right now, this act enables states' attorneys generals to enjoin any further violations. If they find out an organization is violating this act, then you could go to court to stop it. They can enforce compliance. So for instance, they could make you delete relevant data if you're an organization that's collecting that data and turn it over, they're going to make you delete it. There's you could obtain a permanent, temporary, or preliminary injunction. You could obtain civil penalties. And then there's you could also obtain damages, whether it's actual damages, punitive damages, or just, any other kinds. Restitution. My favorite is disgorgement of unjust enrichment. So the idea being that if you're collecting data, that you are making claims of you're doing something with that data, like you're protecting it, it's anonymized, you're never sharing real, identifiable data, everything's anonymized. And then it gets re-identified later because it truly wasn't anonymized. It's really hard to make a claim that the data can never be re-identified by a third party, right? So disgorgement is literally saying, not only are we going to make you, delete any of that data that you should have deleted, because you shouldn't get fruits of the poisonous tree here. You shouldn't have made those claims if it's not true. But you could also force a company, the FTC could force a company to disgorge the very AI model that they might have trained with this data. And so this really has some significant effects on tech companies. And so, like it says on the last line here, the state's attorneys generals would also be allowed to sue violators under this federal act. So it's not just the federal government who can bring an action, but any state's attorney general can bring an action. Not to say they all will, some state, right, based on politics, but they are allowed to under this law. Now, for FTC guidance, we'll go back. Yeah, let's go back to the slide before. Yeah, perfect. Okay, because Vaibhav goes next, but I do have a lot to talk about on this one. So with the FTC guidance, there's, mostly addresses how the federal law and, currently protects private medical information. So that would be HIPAA, and we call that the data set that's protected there, protected health information, or PHI. And so the guidance basically it explains how PHI relates to abortion and other sexual and reproductive health care, clarifying that healthcare providers are not required to disclose private medical information to third parties. just kind of reminding them if states come to you and whatnot, here are your rights as a practitioner. You're not required to share that data. The Department of Health and Human Services, they further explain that disclosures for purposes that are not related to healthcare, so if you wanted to disclose to law enforcement officials for, based on the subpoena, they're only permitted in a narrow circumstances that are tailored to protect the individual's privacy and support their access to healthcare, including abortion care. Then the FTC also addresses that the extent to which private medical information is protected on personal cell phones and tablets, and then they provide some tips for protecting individuals' privacy when using, period trackers and other health information apps. And so some tips, for instance, are they explain the privacy rules, restrictions on disclosures of protected health information when required by law for law enforcement purposes and to avert serious threats to health or safety. And then the Office of Civil Rights, which is a division within Health and Human Services, HHS, they're the ones that, they're an enforcer of breaches and such. So within HHS. They issued guidance for individuals about how to protect the privacy and security of their own health information when they're using their personal cell phones or tablets. And, in most cases, the HIPAA privacy, security, and breach notification rules do not protect the privacy or security of individuals' health information when they access or store it on their own personal devices. And this is because it's on their devices because they put it there, not for purposes of collected by a third party for payment, treatment, or operations of health care, right? So therefore HIPAA doesn't apply. And so, basically OCR, part of HHS, is educating people on where this gap is, so they know that, this will not be considered PHI. This is just considered health-related data, and thus does not have the same level of protections as it does under HIPAA. It also provides tips about steps that an individual can take to decrease how their cell phone or tablet collects and shares that health data. Especially if it's doing it without their knowledge, like here's the settings, here's how you go do that. How do you turn on and off location services on an Apple and an Android phone? What are the best practices for selecting apps and browsers and search engines that are recognized as supporting, an increase in privacy and security. And so, it's meaty, but and not much of that is new, but a lot of this guidance is really going out there to help, educate. Most people aren't following privacy like I do as closely. So with a lot going on right now, they're trying to at least educate on what you are today under today's laws with the upending of Roe. What is that line between federal and state action, and what can befall you. And so with that intro, I'm going to now turn it over to Veet, who's going to talk a little bit about what does that mean for tech companies, and how do you embed this into your processes and make sure you're, de-risking?
Awesome. Thanks, Deborah, for that. In fact, like a lot of what you talked about, it's sort of all connected, right? So each department, or even the FTC, or the clarification by HIPAA, you can actually tie them up, and all of them are talking about certain kind of data types and certain kind of data flows that originate from an app, and that needs protection. So I'll just quickly break down the FTC guidance, and there are sort of 4 buckets that you can put the guidance into. And we'll go into detail into each one of them. But broadly, if you look at it, one is on a very, very high level, it's, hey, what's the data type that you're collecting, and if FTC considers that as sensitive. Second is there are certain data flows to, it could be to an SDK, to a data broker, to an analytics vendor that could be sensitive. The third is about anonymization and certain statements that company makes. I think that this will be interesting, especially I think, Deborah, I'll lean on you to get some insights here. And finally, the guidance talks about learnings that you can take as a company from the past actions, past fines, investigations, and settlements. So we'll do like a quick case study. We'll take one example and do a quick case study as well in the webinar. So yeah, so the first thing, let's dig deep into the data type. So this I feel is quite interesting, right? So First of all, the first two, which are considered sensitive, which you can see even in the act which Deborah was mentioning, Location and Health Data Act. So especially if you combine location and health data, this gives a lot of information about an individual, right? So you can literally identify and get the health information. So I think I was reading about one of the study wherein on one of the data broker, you could literally target women who were visiting these abortion clinics and target them via advertising, right? So it has some real life implication, and that's why FTC is warning about certain data types like location data and health data. We will go into detail of what it means when we go into the compliance section. Um, Another interesting piece could be the app itself. So sometimes the app itself could be sensitive. So for example, if it's a planning app or a mental health app, so if a user itself of that app could be, that information itself could be sensitive, right? So there it might not be like a health data, but like an identifier, like a user ID or an email of a mental health app is sensitive in its own. And yeah, finally, that's just observed data versus data where you are sharing. So sometimes explicitly you are sharing data, sometimes your devices are observing it. So all of this is what FTC is unpacking for companies and saying, hey, look at the data types that you're collecting, because that's sort of the first, I would say, privacy threat that could be in your app. The second thing that the FTC leans on is data flows, and this sort of becomes important because what FTC is trying to say is that, hey, once this data flows to your ad SDKs or your data brokers, the recourse to a consumer or to a company actually stops, because then that data gets sold to multiple people, right? And there is no real control there. It could be sold to the government, it could be sold to another third party to do targeting or profiling, which what really means for a company is that, hey, first of all, look at what SDKs you have embedded in your apps, and there will be a lot of them. And second, look at the flows to these SDKs and data brokers so that you're aware and you can minimize the data meaningfully. Third interesting piece to the puzzle is anonymization, and what FTC talks about, deceptive statements about that. So over to you, Deborah. I'm sure you would have seen like shades of anonymization and different kinds of it. So yeah, I would love to hear from you. What does FTC mean by deceptive statements about anonymization?
Yeah, so this is actually like, this is my interpretation of what they mean, and by no means should this be viewed as legal advice. Okay. Anonymization is really difficult to achieve. For one thing, there's a difference between somebody coming, who wants to be anonymized and like show up in a public environment as an anonymized person, like the state of being anonymous. There's another, what we're talking about here is companies that have collected too much personal data, like quite honestly, without, but they want to be able to share data with third parties and insights derived from that. So in order to do that, they have to render this data set safe to do so, right? And so for a long time over the years, we've had different standards for this in the healthcare space. And for HIPAA, we've had a standard called de-identification, which means just get rid of all the identifiers. If you get rid of all the identifiers, you're good, right? But as time has gone on, that's not enough to render the data set, unidentifiable again. Like it's not enough of a claim. And so over time, that standard of de-identification never really went anywhere beyond healthcare, because it just didn't make sense for businesses. Once you anonymize a data set, you're unable to use that data as an identifier or pseudo identifier, right? To be able to, use it on behalf of the individual themselves for any reason. So what I mean here is that, like, when a company is anonymizing their data, it's usually for the company's own benefit, so that they could go and, sell that anonymization, and people can get, or anonymized data set, so people can make, money based on the insights derived from it, right? Or you could train models on it, or all of these things. But if you're selling data and that data and you're making the claim like, no, we're not selling your data because it's not linked to an identity. It's all cool. It's anonymized. And then later on, you can realize that, it only takes like, very few number of data points. It could just be 2 data points that could, make it really, really easy to re-identify. And therefore, in many ways, anonymity is a ruse. for a lot of, in some ways it's not. But so if a company is basically saying that they achieve anonymity before they ever are, using your data in a way that you don't consent to, and they, it gets re-identified, those people are going to try to blame the company that re-identified it, not themselves. That's what what's happening right now. And so to really stave this off, it's like, no, you made the claim that it's anonymous. A third party that you shared that anonymous data with would not be able to re-identify it if it was anonymous, truly.
Yeah.
So this is an example where the highly effective tool of disgorgement can come in, where the FTC has real, powerful tools to be able to say, all that entire business line that you have, that you built on these models of things that you said were anonymous, but they're not, get rid of it. And that can really set businesses back. They really should understand that this is a big deal. And quite frankly, I'm in favor of it. I'm in favor of disgorgement if that's what it takes to get businesses to finally do what's ethical and actually only make claims that they're going to stand by.
Thanks, Deborah, for this.
Sure.
I think the final piece to the FTC guidance is learning from the past fines and investigation. And these are a couple of the investigations that they talk about. So one is Kerbo by Weight Watchers, another is OpenX and Flow Health. So Flow Health will do a case study. But what was interesting to me, and this is tying back to what Deborah was mentioning, was in the Kerbo or Weight Watcher case, not only FTC directed the company to delete data, but also to remove any product or even algorithm derived from that data. So this was already a part of the Kerbo sort of ruling. So it's actually quite interesting that is shaping up. I think next week we can actually go down and look at Flow Health as a case study. I mean, this is again, from a perspective of understanding the guidance, this is a really, really good case study, because it talks about really what happens in code and how your privacy policy is positioned and what can actually go wrong, right? So Flow Health, of course, is a super popular app. It's a period tracking app used by women all over the world. Over 100 million downloads and being featured on top of App Store multiple times. And again, since a lot of sensitive data is entered into Flow Health, one of the key promises that the company had made was that, hey, we will not share any health data with any third party, right? So that was sort of the context of the Flow Health. And if you sort of dig deep into the privacy policy at that point of time, which was sort of the basis of the investigation, it was actually, again, reassured by the company that no health data will be shared. And in fact, they had mentioned a couple of the third parties that were integrated in the app. One was Facebook Analytics, Google Analytics, Flurry Analytics. So these are quite popular SDKs or third-party APIs, which are generally integrated into mobile apps and are used to do certain analytics or even ad targeting. The thing was that it was clearly mentioned in the policy that, hey, we will not share any health data. It will be non-identifiable. So all I'm saying is that the promise of not sharing health data was sort of crucial for the growth of the company, because it was building that trust for the adoption to happen. And this sort of came back in sort of user stories as well when this entire thing broke out, right? So this was sort of the context of the Flow Health case, right? So this is a popular mobile app, and there was a sort of a promise in their user-facing privacy policy of not sharing health data. But in case, what was happening in reality was sort of little different. And just to take a step back, what was happening was it's actually pretty common. So as I've been a product manager, as product managers and developers, we tend to measure a lot of stuff. And one of the measurements we do is how does our feature get adopted? So we like to measure, we like to do this something called usage data. So we will send usage data or product data or usage events to our analytics provider, like a Google Analytics or a Segment or a Mixpanel, and then try to see with this new feature that we've launched if it's getting adopted or not. Now, if I'm a product manager, let's say at Spotify, and I have a new feature for discovery of podcasts, right? So measuring how well that discovery is going is actually pretty harmless. But in case of Flow Health, this was actually pretty it had a real life privacy risk. So what was happening in Flow Health was these usage events, they were actually revealing the health information of an individual. So if you can read through the slide, there were two actual events which were detected. One was about the week of the pregnancy of the user. Another one was which were disclosing information about menstruation reminder. And this was coupled with an individual identifier. So it was these usage event within personal identifier of a user, which was flowing to these third-party analytics vendor like Google Analytics, Facebook Analytics, and Flurry Analytics, right? And this was what the case was all about, right? And again, if you take a step back, this is something which can very easily happen with any company. This drift of what you have promised in a privacy policy versus what's in your code can happen to anyone. And this happens because generally code development or product development happens at a really fast pace. And then there is no real easy way to make sure, whatever you're promising is what is being followed in code. So I'll touch upon that towards the end of the webinar, where we'll show how you can leverage Privado to do that. But before we jump in there, I thought it'll be nice to sort of cover, how you can comply, what are the steps to comply, and what you can do today to make sure you are complying with the FTC guidance. So again, three large buckets that you can look into. One is go back and look at your Android apps and iOS app and see the data type you're collecting and sharing. So that's the first big bucket. The second bucket is privacy notices. And I would say they have also exploded over the years. So we'll talk about that as well. And finally, identifying third parties, be it via integration via SDKs or APIs. So that's the third kind of thing that you need to look at. So yeah, jumping into the first type, which is identifying these data types. Again, there are a lot of data types that your app might be collecting or sharing, but these are few which I feel are interesting or sensitive that you should definitely look at. So health and location, again, they are top of mind as per the FTC guidance. And location is quite interesting because location data can be collected in multiple ways. And I'll share a few. So if you have a mobile app, it could be via permission. So course location, find permission, precise location permission. These are some permissions that your app could have to collect location data. Another one could be GPS. So that could be from a Fitbit or other devices. Another one, interesting one I feel, is IP address. So if IP address is flowing to add SDKs, they can literally figure out the course location of the user from that. So it's that itself is enough to link back to location. And then there could be other sensors. Your car knows a lot about you. I think there are enough articles on that as well. The second piece is
it's interesting with the IP address. You hear so many Americans and ad tech folks go, kind of lamenting that the EU considers IP address to be personal data, to be, in some ways an identifier, not even just linked to an a person. But here you could see why. You could see why in what you were just describing, how it can be an identifier, a link to, identifying who that person is. And so, perhaps we should, in the United States, we should rethink our view on IP address.
Oh yeah, and then one easy way for especially privacy folks and security folks is to just look at the Play Store data safety report by these ad SDKs, and you can see they will talk about how they infer location data from IP addresses. So in their reports, they have already mentioned that. So it's just like a couple of searches and you will find that out. So yeah, IP address I feel is interesting kind of data flow that at least we should try from a flow perspective if it's going to any third-party SDKs. Another one is device. So device is where your identifiers will start to play, right? So this could be like an ad identifier. It could be like IDFAs of Apple. It could be a unique device ID. So this could all be used to identify a person individually and then target them. Health data, I think anyways, if you are collecting health data, then I'm assuming you will be a little more paranoid about it, about what all data your app is collecting. So the easier one I would again say is direct data. So someone is filling a form about their weight or their health condition, that'll be easy to catch. I think what would be interesting again is like cases like we discussed in Flow Health, wherein there would be some usage event like there was for Flowhead, which you might not be aware of, and which would be reflecting the health information of an individual that you might be collecting. So do look for those events or those data types that you might not be aware of and your app might be collecting. And the fourth bucket that I found was interesting was some weird data types that you might not be thinking regularly. And these might not fall in the general category when you think of privacy, but they could identify or they could tell about the user a lot, right? So one was simple identifier like email addresses, user IDs, device IDs of any sensitive app. So it could be, as I give an example, it could be of someone of a parent planning app or a mental health app. So if an email address of a mental health app gets breached, all you need is that email address to know a lot about that person. You don't need like, their history. That itself is enough to tell a lot, right? So in case of such apps, identifier becomes super sensitive. Another one could be, and this is an interesting one, and it might not be there in your company, but I've seen this practice a lot, wherein app developers, they collect data on what other apps are there on the phone. Now, of course, if that information can reflect, so for example, for a user, if they have any other app which is sensitive, and you collect that, and then you can actually use to track a user. So there are these side cases of data types that you might not fall in the traditional categories of location, health, and device, but they can actually disclose a lot about the user. So it will become important to do that kind of threat modeling as well as you advance your privacy program. So this would be the first big bucket of identifying the data types, auditing your apps, figuring out what data types you collect and share. The second big piece would be to identify third-party data flows. And here, start with SDKs and APIs, because that's what will be the major one in your mobile apps. And specifically, if you see, some of them are data brokers. So typically, these third-party SDKs could be for analytics, for your data warehouse, like AdMob, like which are like data brokers as well, right? So these could be a couple of these. The most important, or like one thing, if you can take back from here, is if you have ad SDKs or if you have any kind of third-party integration, go back and audit those flows. What data is actually flowing to each of them, and whatever you are promising to your end user, is it what is actually in code? Are those data flows in compliance with your user-facing privacy policy? So I think that would be one good thing that you can do as privacy and security teams. And finally, privacy notices. So I think this has also changed over time a lot, Deborah. So I would lean on over to you to give some insights here.
Yeah. So, it's interesting because I like to very often compare what the threat modeling of the security world that, with static code analysis to that of, we're shifting left in the privacy world. And so the same way that your attack surface just keeps growing and growing as the internet and web services continue to grow, privacy notices have gone from, being something that's just like a link at the bottom of your website that you have to have for, a variety of reasons, to all of these just-in-time notices, where it's almost like you're making far more claims in far more areas of your business that you need to comply with. Otherwise, you will, you'd suffer a lack of trust, number one, from individuals, but then, potential regulatory action or other problems, right? So here, instead of just a privacy policy, we now have the App Store nutrition labels. You have your Play Store data safety label, which is basically similar to the concept that the App Store has for Apple. And then all the different just-in-time notices. And so, each one of these could potentially, is your interaction with an individual who is saying, oh, okay, based on what you're telling me, I feel safe or not. I'm either going to opt in or out of using your service based on this information. And so, you have potential liability if you do not, have this all written in the code and make sure that it's accurate. And that, you're not, people are not, fraudulently making choices that based on something that's not true, right?
Yeah, I mean, 100% agree, Deborah. So we did some work with app developers on generating accurate data safety reports. So I just feel this sort of surface of your promises have increased multifold, especially with just-in-time notices, right? So you might take location permission and then give context of this is why we are taking location permission, and then that becomes another thing to monitor. So yeah, I would definitely say this is one place to audit and make sure whatever you're promising, and then if it's the reality, what's actually happening in code matches that or not. So yeah, I think this sort of brings us to the end of the sort of how do you comply. So again, 3 buckets: audit your data types, audit your data flows, and audit your privacy notices. And with all 3, you can actually create a true picture in terms of guidance that FTC has given. And like just wrapping up before we go into Q&A, just like spending a couple of minutes how you can what Privado is and how you can use Privado for the same. So yeah, at the heart of it, Privado is a privacy code scanner. For security teams on the call, they might be knowing of SaaS tools, which are more security scanners. So we have built something which is specifically for data security and data privacy. What Privado do is it will scan your product and application code to automatically tell you the data, the personal data or the data types your app is collecting, and all the data flows from your app to third parties, SDKs, and even leakages to logs. And once you have that, what you can do with Privado is enable privacy as code or compliance as code, and literally write all the promises that you've made in your user-facing privacy policy as a part of your code checks. So which means that if a new product feature comes in which does not comply with your user-facing privacy policy, Privado can create an alert, stop that change from going live, and actually save you a lot of headache from regulators or FTC or some negative press, right? So that's about Privado. What I felt would be a nice thing to do is take an example of it. So what we're going to do today is take an example of a health app which is leaking personal data. So it's a leaky health app, and I'll show you how Privado works and how you can use Privado to find these leakages and data flows in your own app.
Is this an intentionally leaky data app, like one that's been, kind of
No, it's actually
that's for this purpose, for the demo?
No, not really. So it's something which is available on GitHub that we just scanned. So it's something that we did not create.
Cool.
So it's actually available for anyone to scan and audit. So yeah, and we've scanned a bunch of these and we found a lot of leakages, and we'll be talking about that as well in the coming weeks. But yeah, so here's an example of a healthcare app. So the first thing that you'll see is Privado has detected that this healthcare app is collecting 8 data elements. Some of it is sensitive, and there are some flows that we have identified. So again, from an audit perspective, we already know the data types that this app is collecting. So we can quickly have a look at that. We can categorize them. So these are your usual suspects. So you have your phone number, email addresses, marital status is something which I saw I was sort of surprised, date of birth, first name, last name, and there are some health identifier as well, which is health data. So these are the first bucket is there. So you know the data type, so you know the risk of this health app. And then what you'll see is these are the flows from these individual data element. As you can see, there is this red, which is leakages, and then there are two sharing. One is with Google AdMob and one is with Amplitude. So let's pick the most common one, email address, to see how the flow looks. So again, all of this flow is automatic that Privado has created. What it enables privacy and security teams to do is scan their code and get the information of, hey, my email address is being shared with two third parties. One is Google AdMob, which is like an ad SDK, and maybe you want to stop that flow, and Amplitude, which is your internal analytics platform where you're fine with. Another interesting privacy violation is this leakage, which is your email is being logged into console files, and this is something that definitely you would want to minimize. So you want to remove any data which is going to logs. So this was one example. I find health identifier is another interesting one where that's also being shared with Google AdMob and is being leaked to log. So this is another example, and you can look it across, right? So just by looking at this picture, you get the data types you're collecting, the data flows. And if I would be the privacy officer or the security officer of this company, I would really minimize like some of these data types, like health identifier should not go to Google AdMob, and leakages I'll definitely remove. Maybe Amplitude might still be fine. But the thing is, you get this visibility and then you can take these actions. So you can minimize data or change your privacy policy to reflect what's in code. So that's what Privado does. And over to Q&A. So I think we can now sort of look at the questions and open up the. Deborah, do you, after seeing the presentation, do you have any towards the end? Feel free to ask as well.
Why don't you flesh out a little bit about, why it's a problem to leak to logs? Just make that connection.
Oh, yeah. Oh, yeah, of course. So basically logs, if you're writing data to logs, actually logs, a lot of people have access to logs. So a couple of personas that could have is the developer who's building the app. Some other development team might also need logs that might be going to your security logging system as well. So even security team might have access to log. DevOps team might have access to log. So the thing is, once you start to put in this personal data in clear in your logs, a lot of internal people will have access to that and they can actually see. So you suddenly open up this breach vector or data, sort of leakage vector. That's why sort of stopping data from leaking to logs become important.
That makes a lot of sense. So that this way, I want to make clear that the risk here is to the individual's data being more accessible and available to a wide group of people within the org. The org may look at it as like, well, it's not a compliance problem overall, like, because it's not like we breached anything or we shared with a third party. And so, but data leakage still is a privacy problem. And, for the reasons you stated, right? Like it's just widely available. Almost think of it as like privileged data, right? I mean, it's not privileged, does not, this is not a privileged scenario, but I think of it as an analogy like privileged data where, oh no, you could only have like a select group of people who need to know, view certain, information. And then if you make your privilege too wide, you lose privilege. So, you lose your claim to privilege. So it's kind of here, it's almost like you lose your aspect of privacy the more and more people within an org have access to your data.
And then the control also keeps going low and low, right? Once that data enters logs and it can get copied more and more. So it can go from a small logging system to the central logging system to individual teams logging system. So like suddenly like someone, so again, like let's take an example, someone who entered the information about the period tracking app, and then that data goes to log, and then that person's data now suddenly is available to, let's say, 40-50 people inside a company. So
right.
yeah, you would
in the governance issue too.
Yeah, it becomes really difficult. So that's why governing leakages become important.
Would you limit access internally to the logs to certain individuals? I mean, I'd say yes.
Yeah, and I think already security privacy teams do that. Like access control of data is already a big thing. It's already a lot of investment goes there in terms of who gets access to what data. I would say like just following the data minimization principle, which GDPR has baked in. You should minimize data going to logs. We've had like customers who've actually looked at data going to logs and completely removed them because they don't want. But once data enters any of your system where it should not, it'll get replicated. It's like that nice funnel. It will enter, it will get copied, it will get inferred, it'll get. So wherever you can minimize data where it's not needed, you should do that. I guess we are almost towards the end of the webinar. Since if there are any questions, feel free to ask. If not, then we'll save a couple of minutes on a Tuesday morning for you all.
Yeah, I have something to end on. I think I do want to, after everything I just stated about, clearly I'm a little jaded about how our privacy laws have or have not been enacted or enforced or whatnot. But what we should all pay attention to is that the FTC has tremendous influence on privacy actions in the United States because of their broad, Section 5 power to be able to bring a claim against any organization that has deceptive trade practices or unfair trade practices. And those are two separate two separate buckets, unfair and deceptive. Because of that, they have been able to, over the years, take action, and then their enforcement settlement actions, where they, require companies to, have 20 years of audits, and for 20 years they have to be, report how they're implementing the changes that the FTC required in that action. It has the effect of making law. Okay, so all of the holdings end up becoming a hodgepodge of, here are things you don't want to do as a company, and you find out after the action that this is the thing you're not allowed to do. So pay attention to this FTC stuff. This isn't just to me, I'm like, oh, another privacy bill, great. Tell me when it really is going to pass. In this case, this FTC stuff, I really do think has teeth. They've been, this is not new for them. I mean, maybe disgorgement of data and disgorgement of profits is a little more new. They can flex that more often. That's new for them. But generally, this has been one of the biggest drivers of privacy compliance requirements in the United States, as is through FTC enforcements. So pay attention, to the FTC and for the future here. And I bet we'll be doing like an update webinar in like a year or so. That long. A
lot of action at least is planned, I think. So yeah, we'll definitely do a catch up on that. And one thing, what you mentioned, one thing that I definitely agree with is as you start to look back on fixing things, that's been one of the big challenges for companies, right? As these laws came up, everyone was struggling to keep up, but now they have matured enough, and you want to sort of fix the leak right at the beginning, right? You want to shift it right at the source, and focus there. Because if you don't do it, the problem is, if you don't fix things at the code level, at the collection level, where decisions of data collection happens, what ends up happening is that data will get replicated multiple times, inferred multiple times. So if you have to really minimize data, do it at the application level. Like, look at your mobile app. You can do it with a tool like us automatically, or even if you don't use us, do it manually with your developers. But if you don't fix it at the code level, if you don't go and find your privacy risk in code, they will multiply in your company, and you will see them multiply, and then one fine day, one thing will break, and then you will see the effect of that. So I would say, security did it and shifted very, very left, and that helped them. So I think it's right time for privacy to do that as well. So with that,
Right,
I think,
agreed. And when we say shift left, we mean shift left into the development process, the product development process. Not just the whole life cycle of data, which is traditionally how privacy folks have been talking about protection. But we really need to be working hand in glove with the engineers, those who are coding the websites, those who are, coding to hard requirements and can't code to things like, reasonableness, right? Like that lawyers often, the world of the gray area that the lawyers play in is not good enough for, you can't code to that, right? So I totally agree with that. And, I'm starting to even see the DevOps space within organizations incorporating more privacy tools for their developers. So, just working in the space, working with the rise of privacy tech, this drive to shift left is not going away. It's only picking up speed. And this is great for all of the people higher up at the stack, like the analysts, the attorneys, the consultants and whatnot, because, it'll give them peace of mind that, once something's addressed in the, engineering stack, that you're shipping a product with privacy by design, right? And it's those assurances and, level of compliance and whatnot that is going to not only delight your regulators and your DPOs and stuff, but your customers. You're gonna garner trust, especially if your customers are, enterprise folks, right? Like, do you know what you're doing is important. And there's more and more focus on, the threat modeling for privacy way before, you ever ship anything.
Awesome. So it was fun and we're almost on time. So thanks, Deborah, for the webinar, and thanks everyone for joining in. It was great fun to talk to you, Deborah, and hope to do one more again pretty soon.